Is there a formula you can use to win your Social Security disability case? Something that if you follow steps 1, 2, 3, 4, 5, you are guaranteed a win. My name is Jonathan Ginsberg. I'm a Social Security disability attorney, and when I talk about a formula, I actually should really frame it as a framework because I don't think there's any specific formula, but I can tell you that there are some steps you can take that will greatly improve your chances of winning. And when I talk about these steps, sometimes it's more what's in your medical record, but these are maybe the characteristics of a winning disability case, and if you can fit your case into this, your chances of winning go way up. So first in this framework would be a clear diagnosis. Disability judges are much more impressed with cases where there's a firm diagnosis as to your problem. Even if the diagnosis could be one of three things. Sometimes you see that where it may be this, or it may be that. That's fine, but there needs to be some general consensus as to what is going on. When you have a case, medical record where there's no firm diagnosis, the doctor does not know why you're having pain in your leg, why you're having pain in your back, much more difficult than a case where there's a clear diagnosis of herniated disc or an ACL tear, something like that. So a firm diagnosis is really framework step 1. Step 2, or framework step 2, would be treatment with a specialist. I'm finding more and more that if you go to a family doctor, an internist, and that's the only doctor who's seeing you, that does not really move the meter so much with Social Security judges. They want to see a specialist. If you've got rheumatoid arthritis, they want to see treatment with a rheumatologist. If you've got back pain or a herniated disc or disc involvement, they want to see treatment with an orthopedist or perhaps a neurosurgeon. If you've got diabetes, they want to see an endocrinologist. Again, family doctors can do a lot of good things, but generally speaking, if your condition is serious enough to be disabling, it's probably one where there's a specialist that could be offering specialized type of treatment, and your case is going to be a lot stronger if you're treating with a specialist. Number 3 would be ongoing treatment. I'm finding more and more that judges are reacting badly to gaps in treatment records. And so it's much better to have 3 or 4 visits a year than to go 18 months without seeing the doctor. Even though I don't think it's accurate a lot of times, the conclusion that seems to be made is if you're not going to the doctor, you must not be that sick. And of course that doesn't take into account the fact that a lot of folks don't have insurance or don't have money to go to the doctor, but judges expect you to do something, whether it's going to the emergency room or to the free clinic, but go someplace. So ongoing treatment is a really, really important step and a really important part of that formula to win. Number 4 would be that you want to show that you're compliant with what the doctor is suggesting to you. If the doctor tells you to stop smoking, or at least give it a really strong try. Lose weight, try to lose weight as best you can. Take a certain medication, take that medication. I've seen far too many cases where the medical record says that the patient was not compliant with medication and therefore I can't do anything more for that person. So you want to follow the protocol as much as you possibly can, and if you find you're having terrible side effects, you want to report those to the doctor so that gets in the record as well. But compliance for treatment, and then this part B of that would be that the treatment that has been prescribed to you is not effective. So ineffective treatment, despite your compliance with it, is a hallmark of a case where the person is not getting better with treatment, therefore a disability is much more likely. So again, comply with the treatment, but the record should show that that treatment has not been fully effective in alleviating the symptoms. And I'll give you a corollary to that. If some of your symptoms are being improved with treatment, let the judge know about that. You're much more credible to go in and say, you know, I filed for disability, I had 4 things wrong with me. I had breathing problems, I had back pain, I had diabetes, I had numbness in my feet. Well, the breathing problems have resolved because I'm taking a certain medication for COPD. You're much more credible if you tell the judge that, yes, this treatment has worked, but by contrast, the treatment for the diabetes has not worked, or the treatment for the herniated disc has not worked. So corollary to the notion of complying with treatment is be aware of situations where the treatment is effective and let the judge know it's been effective. That greatly enhances your credibility. Number 5, and this is really important, not just at the end when you're getting ready for your hearing, but throughout the course of your treatment, you want to report relevant symptoms to your doctor. When I mean relevant symptoms, those would be symptoms that would impact your capacity for work, since in a disability case, that's what we're trying to prove. You're not able to work. So, for example, in a diabetes case, the type of symptoms that would be would make work difficult would be frequent urination. A lot of folks with diabetes are thirsty all the time. They have to go to the bathroom all the time. So if you're going to the bathroom every 30 to 45 minutes, that is a vocational problem. Numbness in the hands and the feet, that's going to eliminate jobs on ladders, ropes, scaffolds, hazardous, around hazardous equipment. It may eliminate jobs involving driving a forklift or a vehicle. Anything that requires fine motor manipulation, that would be a problem if you have numbness in your hands or your feet. Vision problems, and again, I've won a number of cases when the record shows my client has 30 to 45 minutes, 3 days a week, where their vision's so blurred they can't do anything. So report those problems to the doctor. And there will be other things that may be more annoying, but they're not going to necessarily be work problems. Those are less important for my purposes in the disability world, but just be aware, and when you talk to your doctor or talk to your lawyer for that matter, which are the symptoms of my condition that are most vocationally relevant. And you need to focus on those when you're reporting your status to your doctor. Congestive heart failure is another one I see a lot of. Things like shortness of breath, frequent urination from diuretic medications, extreme fatigue. These are all things that would eliminate categories of jobs, or ideally all jobs. Herniated disc. A lot of folks with a herniated disc are going to have radiating pain into their legs. That may make foot controls impossible. That may eliminate ladders, ropes, scaffolds, kneeling, crouching, crawling. All of a sudden, a lot of different types of jobs are out of the picture. Then, when you factor in pain, when you factor in the need to lie down at regular scheduled breaks every 3 to 4 hours, that's going to make it very difficult for any vocational witness in a hearing to find that there is a work you could do. And the 6th thing is, do you have support from your doctor, ideally the treating specialist, in the form of a functional capacity evaluation or narrative report that identifies work limitations so that you would not be reliable. Something to the effect that you are missing 3 or more days of work a month, or you're taking unscheduled breaks every 45 minutes to an hour. Those are problems in work, or that you would not be able to get through the workday without lying down, or you're not able to get through the workday without breaking down emotionally. You're not able to interact with coworkers, supervisors, or the general public. These are all work capacity limitations, which is the language we speak in the Social Security disability world. So if I had to say there's a formula, those 6 things are the most important things to me as part of that formula. And if you keep those things in mind, even write them down, and talk about them with your lawyer, you will have the right mindset going into your hearing, going into really throughout the whole management of your case, so that when it does come time to get in front of the judge, you speak the same language as the judge. Hope you found this helpful. Again, Jonathan Ginsberg here. Visit my website at ssdanswers.com for my free Secrets to Winning Disability Survival Kit. You can ask for a free case evaluation. I'll take a look at what's going on with you and see if we can help you. And if I can be of assistance to you, please let me know. And by the way, if you like this video, please give it a thumbs up, like it on Facebook, subscribe to the YouTube channel, like our Facebook page. We're always looking for different ways to communicate with the folks that at least I'm trying to help out there. Again, Jonathan Ginsberg, and I do wish you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the Survival Kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.